Hi, I'm Mike Fiffick here at Fiffick Law Group in Pittsburgh, Pennsylvania, and I'm talking to struggling business owners out there who are having a difficult time during this COVID crisis. You may be tempted, because finances are tight or the money is short, to not pay paychecks to your employees, or maybe only partially pay those paychecks. If that's the situation that you find yourself in, I'm here to tell you that that would be a very big mistake for you, and I want to talk to you about how to avoid that problem, because there are some remedies available out there for you. So Pennsylvania has a law called the Wage Payment and Collection Law that requires you to pay your employees for work that they've done or vacation time that they've accrued and they're taking in a timely fashion and completely by a certain date. You're required to notify your employees when their regular pay date is, and then you have to stick to that. You can't change it all of the time. That would be a violation of the law. Whenever the regular pay date comes, you have to pay them all of the wages that they're due. You can't pay them partially or give them a short paycheck of some kind. The law requires you to pay that employee everything that they're entitled to. And that really covers all types of wages, whether it's hourly earnings or salary, bonus, commissions, employee benefits, vacation time. Anything that you have to pay to or on behalf of an employee is going to be considered wages covered by this wage payment and collection law. Now, if you fail to pay all of the wages that are due to these employees for 30 or more days, you are subjecting yourself to a potential penalty of 25% of the unpaid wages, or $500, whichever is more. So that's what you would have to do if an employee files a claim against you and they are successful in that claim. In addition, if they file a claim against you in court and they win, their attorney's fees that they incurred will be assessed against you. Now, if you're successful, the law does not entitle you to recover the attorney's fees. So many business owners who are defending a suit for unpaid wages under this law find themselves paying not only their own attorney's fees, but the attorney's fees of the employee or employees that have filed claims against them. Most importantly, if you are a business owner and you are a decision maker who has decided to pay or not pay or pay short your employees, you can be personally liable for the unpaid wages. So if you're a limited liability company or a corporation, that limited liability protection that normally protects your personal assets from claims relating to your business will not protect you from personal liability in a suit filed by an employee for unpaid wages if that employee is successful. So that's why I say it's a big mistake to not pay your employees all that they're entitled. Now, you might say, well, I don't have the money. What am I supposed to do about that? There are some solutions available for you out there as a result of the Federal CARES Act that was filed. And there are some SBA programs that you can apply to as well. The first thing that you should ask yourself is whether you're an essential business and allowed to continue to be open and operating during this COVID pandemic. So you should be constantly checking the governor's list of essential and non-essential businesses to make sure that you're allowed to be open and operating during this time. If you're a non-essential business, you should not be operating, and that should eliminate any unpaid wage issues for you. You might consider furloughing or laying your employees off and encouraging them to file unemployment compensation benefits. During this COVID pandemic, claims for unemployment compensation benefits will not adversely affect your rating for purposes of paying into the system. So there's really no reason to challenge or to discourage your employees who you've laid off from filing unemployment comp benefits and let them collect benefits under the system. Now, if you need to continue operating and you're allowed to continue operating, there are two federal programs that you might consider applying for. Both of them are SBA programs. The first is an economic injury disaster loan. You apply to the SBA directly for that. It's a low interest loan that is paid over 30 years, so that your monthly payments will be very low. And you don't have to start making payments on that for 6 months after your loan is approved. You can also ask for an emergency advance of the loan amount, and once you're approved, you can get up to $10,000 advanced to you before the balance of the loan money is paid. The second program is called the Paycheck Protection Program, and that is also a loan program available to you through the SBA. That is also a low interest loan. I think the interest rate's 1%. You can earn forgiveness of some portion of that loan. So some of the money that you borrow will not have to be paid back, provided that you spend that money on covering payroll and you keep the majority of your employees. And you also don't have to start making payments on that loan for 6 months after the loan is approved. So those are two great loan programs that are available to most small businesses. If you have less than 500 employees, you will probably qualify for one of those businesses, for one of those programs. So there's really no reason to be short of money right now. You should be able to apply for those programs, get the needed money to float your business, continue paying your employees in compliance with the wage payment and collection law. If you need any help with any of these things, understanding your obligations under the wage payment collection law, or you need more information or help applying for an EIDL or a paycheck protection loan, please call us. Our lawyers can help you. Thank you.